Good evening, everybody. Full house here at SZV. Welcome in our office, welcome at SZV, and thank you for taking your time and be here tonight with us to gather some more information about SZV's rules and regulations, specifically aimed at employers. Thank you again for your time here. And let me start by introducing myself. My name is Ms. Parveen Boortje. I am the Chief Customer Officer of SZV. And I have the honor to welcome you here today. And also to inform you that this is the first of many activities that SZV will undertake this year in order to inform and exchange information with our employers. There is tons of information that we would like to share with you. Some of you are employers for a long time here on the island. Some of you are here for a shorter period of time. But it's always good, in whatever circumstances you are, to gather some information about the social and health insurances. Today we are here with fully equipped staffing. I would like to take a moment to thank my colleagues that are here present today from the various departments of SZV to assist you, the employer, to answer all kinds of questions that you have, to exchange information. And I would like to encourage you to ask your questions even after our presentation. We will have a main speaker this evening, but there is enough time to also go into detail in your personal questions and your personal situations. So please do not be hesitant and come forward. If you do not want to do it here in the plenary session, it's also possible to have one-on-ones with our staff. So I would like to encourage you to take that opportunity and have a one-on-one meeting with our staff present here today. I would like to take this opportunity to present to you our main speaker, which is Mr. Reginald Willemsberg, our corporate strategist. He will introduce the SZV rules, obligations, did you knows or didn't you know, and all the facts and figures that is relevant to you. And I would like to give a warm welcome to Mr. Reginald Willemsberg. And Mr. Willemsberg, the floor is yours.
Thank you. Good evening, and thank you for being for the introduction. Wow, I'm happy to see a full house because we were wondering if the people would have, the message would have come outside there so that you would come in. But as we could see that you want information and you come out in full force. As a matter of fact, we'll have to find ways to break the wall so that more people can come in. So many people standing out there waiting for space. But welcome, and my task tonight is to try to give you as much information possible that today is not only geared to employers, but mainly geared to contractors, the contracting sector. This is the first session, like my colleague stated. And we chose to use this, and I'll explain why. Because mainly, as we know, because we had a lady that passed through St. Martin last year, and that left her mark on us. Her name is Irma, and what we've noticed, we have a lot of construction coming up. So because of that, we have a lot of old companies or present companies, that the current companies that we know have been functioning, and also have a lot of new companies, construction companies, new contractors are coming up. So that's why we chose to start first with this particular sector to make sure that in any case, the up and coming for the next few years, that you will have the correct information for you to do the correct things when it comes to the social insurance. The program for today is that we will be talking about the general SZV obligations, the registration procedures, employer and employees, the ZVV premiums, the declaration and payment procedure, the chain of liability, protest and appeal procedure, and ultimately the employer debt services. Please, if you could hold your questions until we finish the presentation so that we could finish it on time and that everyone gets a chance to ask the questions at the end of the presentation. Okay? The SLV, the Social and Health Insurance, is the entity with the task of implementing social insurance legislation. When we talk about social insurance, we're talking about measures to protect employees in the working process and provisions against risk for the insured. Social insurances, by the virtue of being a social insurance, globally, social insurances is based on what we call the solidarity principle, so that we pool all the resources together in order to mitigate the risk that is to make the risk less riskier for the group that is insured. According to the federal ordinance for the sickness insurance and the accident insurance, an employer must be registered at the social insurance, social and health insurances, SLV. According to Article 12 of the National Ordinance Sickness Insurance and the National Ordinance Accident Insurance, what we call occupational accident, it states that everyone is, on behalf of the execution and control task of the SLV, obligated to provide information upon request to the SLV. If so required, it can be requested that it be done in writing. They are also obligated to follow the instructions given by the SLV with regards to the implementation of these national ordinances. And then Article 14 states of both national ordinances that non-compliance with Article 12 or untimely compliance of the obligation mentioned in Article 12 can result in a fine of up to a maximum of 5,000 guilders per case. So that means if we go do an inspection and we find that you have 5 workers that are not registered, we can impose a fine of up to 5,000 guilders per person that we find that is not registered. So you can understand that it can amount to a big amount if you are found to be delinquent. This is an administrative fine that is imposed by the SLV itself, and by defaulting on your obligation, you will leave SLV no other recourse than to take necessary steps to apply Article 12 and Article 14A of these above mentioned ordinances. And of course, we don't want to reach that point, and that is why we're doing what we're doing now, giving information to you so that you know what the regulations are that you have to comply with, and that you can prevent reaching to the point that SLV has to take measures. Next question that we have is who is an employer in St. Martin, the Dutch Caribbean? Everyone who has one or more employees executing labor is an employer. There are 3 possibilities. The first one is you are established in St. Martin as an employer and you have employees executing labor for you on St. Martin. Or you are established on St. Martin and you have your employees executing labor for you outside of St. Martin. Let's say if you have a company here in St. Martin, but you have people working for you in Saba or Statia or even Agueda, but you are registered here and you send out your workers off island to work. Or in the third case, you have a foreign company that is also categorized as an employer on St. Martin. An employer can be a natural person. A natural person is what we call in Dutch, we call it an eenmanszaak, and in English a sole proprietorship. Or it can be a legal entity. A legal entity can be a foundation, an association, an NV, a corporation, partnerships, you name it, all the different possible legal entities that exist that you can register with the SFB. What are the, continuing with the obligations? All employers with employees are required to register them in SFB. This meaning that if you don't have employees, you don't have to register with SFB. That's the, so, because sometimes there seems to be a confusion that people believe that all companies have to register. No. Only companies that have employees. Once you have, even if it's one employee, you have to register. If you don't have employees, even if it's temporary, then you wouldn't have to register. All employees must be registered at SFB, no matter their salary amount or amount of working days or hours. A lot of people believe that you only have to register the person who are below the wage limit. As you know, we have a wage limit. So what happens, some companies register only those persons below the wage limit. But with this article, I'm trying to say that, listen, everyone has to be registered. Why? Because we are not only looking if you're registered, you're insured for sickness insurance. We're also looking to see if you're insured for accident. And the law states that everyone that works, no matter their salary, no matter how many days they work, they are insured for accident insurance. Employee mutations regarding commencement and termination. You are required to, anytime you have a person who's starting to work for you, or you have terminated someone, that within 2 days of this situation changing, or commencement or termination, within 2 days you have to inform the SLV about this. Right now, we have what we call our database is dirty. Why? Because a lot of employers do not comply with the obligation of sending in the mutations. We have employers that have people who stopped working for them years ago, but we still have them online because the employer did not send to inform us that the person is not working. Or you have companies with people working for them for months or sometimes years without registering with the SFB. In both cases, it is not correct, so we need to correct that, so to have the employees to send the correct information. Employee mutations regarding changes in employment. Mutations are not only commencement and terminations. Any changes in your employee situation have to be notified to SFB. What are these changes that we're talking about? We're talking changes in the wages or salaries, changes in the work day, work week, changes in the working hours, changes in the function, whatever the case would be. This information, we need to get it so that we can make the corrections, and also because all these things have an effect on the benefits that would have to be paid out to the by the SFB to the insured. So if we have incorrect information as regard to the working period, how many days they work, how many hours they work per day, what their wages are, wages change, be it that they reduce or that they increase. If we don't get information on time, when we have to pay out benefits, we pay benefits based on the information that we have, at the most recent information that we have. And this information, this mutation for anything else than commencement or termination has to be submitted by the 15th of in the next month after that the change occurred. So if it's something, there was a change in March, by the 15th of April, the SFB must be notified of these changes. Employers must submit, in cases when a person has an accident on the job, the employer must submit accident report form to the SFB. This form can be filled in by the employer, or they could leave someone else fill it in. But on this form, it's stated, is what we call the white accident form. You state exactly all the necessary information regards the employment of the person, the name and information about the accident, how it occurred, and so on. And based on that, we will be able to determine if we consider it an accident on the job or not. And you might have your opinion as to if it's an accident on the job or not, but the determination of something being an accident on the job or not is left up to SFV. If there's any dispute between you and your employee, if something is an accident or not, you fill in the form SFV. If it is determined that it's an accident job, we will let you know. If not, we will also take a decision that is not an accident job and will inform you accordingly. The SFV must be notified within 2 working days by the employer where the employer has ceased operations. If you know how many companies out there that are no longer operating and we still have them as active. As long as a company is active in our databases and our records, and we don't see any declaration, we don't see any information, what happens? Then we go over to making out assessments. Send an assessment for companies that don't exist. And if you're still on the island and you get in these assessments, you have to come notify us, and it's a lot of paperwork, unnecessary work for us, unnecessary work for you if you don't comply with this with doing these mutations. So within 2 days, 2 working days, a company cease to operate. And when we say cease to operate, in principle, it means that you don't have any employees. Then you have to notify us within 2 working days of this change. Or if a company is deemed dormant, also you have to notify us. The employer must declare on a monthly basis. Once you're registered with SFV, every month that you have to pay by the 15th of each month, you have to declare as to what the wage sum is over which the premiums have to be paid. Once this is done, and then of course, once you declare what the premium is that has to be paid, we expect that you pay also. So it would be nice that you pay one time. The possibility exists that you could declare and not pay, but we love it very much when you declare and pay at the same time. Okay? The ZV declarations must be filled and submitted completely and accurately by the 15th of each month, as stated before. The ZV premiums and AOV premiums, they have to be paid by the 15th of every month. So by now, everyone knows that. We have the Cesantia contributions. Cesantia contributions are due each year and must be paid between the 1st of January and June 30th. So you have until, from now, in any case, till the end. If you didn't pay it as yet, you have till the end of June to pay it. And it's a small amount, 40 guilders per year per employee that was working for you on the 1st of December of, in this case, 2017. You check to see how much workers you had on the 1st of December 2017, and you pay the 40 guilders for these persons. What do you need when the next step now is about talking about the registration of employers? Important thing is that whenever you come to register a company by the SFV, we need to see the original documents. We need to see if it's an NV, a BV, or a sole proprietorship. We need to see the original documents. You make your own copies, you bring the copies, but the originals must be also there, because we have to verify with our own eyes that we have seen the original documents. And based on that, we will take the copies, we will keep your copies and give you back your originals. We're not staying with your originals, we stay with the copies. But we need to see the originals to determine, to verify that everything is in accordance to the law. The documents that we need some documents that you need, for example, the excerpt from the Chamber of Commerce, it cannot be older than 6 months. So we need to, and that again is to verify that you're up to date with the Chamber of Commerce, because if you go to the Chamber and you're not up to date, the chances that you get the excerpt is limited. So you will have to pay up and then to do it. So, and of course, you can't register online as yet. So you need to come in person to register, or you send an authorized person to register the company on your behalf. When we say authorized, it's not by word of mouth that, hey, Mr. Williamsburg sent me to come register the company on his behalf. No, Mr. Williamsburg have to put it in writing that Mr. Temmer is coming on his behalf, have to present a copy of my ID to prove that I'm the one who's signing the letter, and also identification of Mr. Temmer so that they know that Mr. Temmer is officially authorized to register the company. And the letter must be stating also that he's authorized to register the company. Or if you give the person that you give a power of attorney, you give him more authority, you have to state exactly what authority you're giving to the person. This is the list of things that we need when you have to register a company. And all this information, I won't go through the list because all the information we have it behind our employer's desk. As you see, we have for the NVs, we have the list, and then also we have for the sole proprietors. There are some small changes that things that you have to submit. One thing that is not on the list but is required is you also have to submit your bank account. So you have to bring your bank account, and sometimes we ask you also to bring some proof that you have an account at a bank that is active. And it's not only for us to know where we could put attachment on your account, because even if we don't know your account number or your bank account, we will go around to find out. But it makes it easier when we have to pay you back, because then we'll make an online payment, we make payments. Did I say a joke? We'll discuss it after. The mutation form is your official way to communicate with the SFB. With regards to commencements, terminations, and mutations. The employer is responsible for filling it in, signing it, and submitting the mutation form, not the employee. What we see sometimes that employees come with a form and they sign it, and when we check in our system, we don't see that the person have authority. When we say an employee can't do it, you can have an employee doing it on your behalf, but you as the employer, the director, the managing director, have to notify us officially in writing that this person is allowed or authorized to sign on your behalf. If we do not have that, we will not accept the mutation that is signed by anyone other than the director or the owner. Okay? So to prevent these kind of things, you have to make sure that you notify us who is allowed to sign on your behalf. And as I stated before in Article 12, you have to notify us on time, and Article 14A, that if you don't comply, you will get fined. Again, a reminder, we want to avoid you getting fines. So cooperate and send in mutations on time. And it's on your own behalf, because if we don't have up-to-date information, you get unnecessary assessments. If we don't have the correct information, you might deny, your employee might be denied the rights that they would have because we don't have their information in our system. And of course, it makes our work more difficult to give you the services that you and your employees deserve. This, most of you must know the mutation form, so I won't go into it. Again, if you have questions specifically on how to fill in the forms, we have staff that will be able to assist you tonight itself, or if you want to come in at another session, make an appointment, you could do that also. The mutation form needs to be filled in out completely. Okay? Only authorized, as I stated before, only authorized person can sign the mutation form. Any correction on the form needs to be initialed by the authorized person. So if there's a mistake and then somebody decide to use whiteout or scratch out information and put the correct information, if it must, the same person that signed the form must initial where the change has been made. So we do not accept for someone else to and especially if it's someone that we don't know has authorization to make corrections and sign it. So please take that into consideration. And like I said, it's important to keep the information in our records up to date. The mutation form can be dropped off in the drop box, because what we do, before it used to be that everyone has to bring in personally and stand in line and wait to give it one by one. What we did since a few years now, that we introduced what we call a drop box, where you just come and you don't want to wait, you just drop it in the box, and within 24 hours we will notify you by email, and we hope that you put your email or your telephone number for us to contact you, and if you have the information, and that the information that we have in our system is up to date, because if you have a number that is no longer valid, we can't contact you, and then you will say that we didn't contact you, but we are calling and we're not getting you. The mutation, so if you have an email, we will notify you by email. If you have your telephone number, we will notify you also about it. Mutation form can be dropped off in person, and when you bring it and you want to be sure that you want to pay it, you want to deliver it, what you do, you come with a copy of it, we will stamp the copy as proof that you deliver it. Important to fill in is column 13 correctly, where here you have to put in the date or a date for how long the contract of the person is valid, or you put indefinite. If you see indefinite, that means, in other words, what you would be usually call the person is permanently in service. But if the person have a definite contract, then you must put a date. So put in on it 2 months or half year. We don't know when the 2 months starting. We ain't sure when it's finishing. Your interpretation of 2 months is different than my interpretation of 2 months. And that's why it's important you have to put a date, a specific date. So if it's 6 months, the person starts working in January, when you're saying it's 6 months, then the end of the contract is the 30th of June. So we know that's the 6 months. So not 6 months. The sickness insurance gives employee in case of sickness, right to medical treatment, nursing, sickness, and sickness benefit. And the sickness benefit is valid for a maximum of 2 years. What we call the loss of wages, we pay for a maximum of 2 years. Accident insurance gives the right to medical treatment, nursing to employee when accident on the job. In case of death, the survivors are entitled to a funeral grant and an accident benefit. If a person, due to an accident, is permanently disabled, then they are entitled to an accident benefit for undetermined time. The system here is regards to immaterial damage, a financial benefit to help bridge the period the employee is looking for a new job, while the new job may not offer the same provisions and career possibility as the old job. And usually it's based on the seniority of the employee, so based on the amount of years that he or she worked. Insured persons for sickness insurance are the employees who are below the maximum wage limit and that work at least 5 days a week. Accident insurance, all employees, including those above the wage limit, are insured. Dependents of the employee for sickness insurance, the spouse younger than 60 years, and children younger than 17 years, or between 18 and 25, as long as they're attending school. And you have to prove that every year, as long as they're going to school, that they're registered, still enrolled in school. Ex-employees younger than 60 years. And where you see 60 years, please read 62, because as you know, the pension age has increased to 62. So that's, I have to correct that. So instead of 60, it's 62. And of course, the dependence of the ex-employee. One important thing, the family members must be residents of St. Martin. For the employee, it doesn't matter if they are a resident or not, as long as they're working, they are insured. But for the family member, the requirement is they must be residents. And residents mean they have, as we call it, an official title. So that means they have a residence permit and they are registered at the census office as living in St. Martin. Information, things that you need when you come in to register an employee: the valid St. Martin ID or passport, the SFB card, that is for renewal appointment of the doctor card, the last 2 payslip or last 4 payslip if paid bi-weekly, evidence of salary received, bank statement, cash receipt, check stub. People might be wondering why we're asking for this thing. Let me explain. You all remember the Brooks Towers? Yeah. Okay. After the Brooks Towers, we had a lot of ghost companies that started and were registering people like crazy, because everybody needed to be registered and needed insurance from SFB, so they could go by the apply for the Brooks Tower. And what happens now? You have people who are doing something incorrect, illegal, trying to register people. And when we are interviewing the persons when they come to get the card, ask them, okay, where's your employer? They don't know. Who's your employer? They don't know. When do you see your boss? Once a month. How do you get paid? And you ask them questions, they can't answer that, give you the correct answers. Based on that, we had to tighten up our controls, and that is one of the reasons we are asking for all this information to verify if there's really a work relationship. And also we ask for a copy of the signed contract. The mutation form needs to be submitted to the SB prior to the employee card renewal appointment. And additional requirements apply for dependents, spouse, and children. Declaration and payment. If your payment for ZVOV or AOV premiums is late, or your declaration is completely or partially incorrect, the non or insufficient declared and paid premiums will be corrected via an additional levy, an assessment. You will get an assessment if anything is not complete. This additional levy will be increased by a fine. The SFB determines the fine in regards to the ZVOV premiums, and the Inspector of Taxes determines the fine in regards to the AOV premiums. For the ZVOV, the fines range between 5 and 20%. Okay, so it increases depending on how many times you've been delinquent in sending incorrect information or not declaring. The fine will be increased, and it starts from 5 and it can increase up to 20%. It is necessary that you pay and declare correctly and on time to avoid fines. With regards to the AOV premium, that the fine is fixed at 15% with a minimum of 15 guilders. Okay? Just some pointers to keep in mind when you're sending your declarations. Remember we talked about companies not having employees or being inactive. If you're inactive and you don't, you're still registered, but you don't have any employees, then you have to fill in what we call a nihil declaration. But if you send in nil declarations, and we have in our records that you have employees, there's a discrepancy there. We're going to investigate it and to find out what's going on, because when you declare nil, that means you don't have any employees. So you can't be declaring 0 while you have employees. Or you have to send a mutation to terminate whoever you have in the system, or you need to correct the declaration, because if you find out that you have people working for you and you're declaring nihil, that means you're giving false statements, we will take the necessary measures to corrective measures. Changing OV risk, and we know some people, maybe they think they're trying to help SLV by correcting the OV percentage. You know, on the declaration form, you have that the loan sum for ZV times the percentage, which is 8.3 for the employer and 4.2%, in total 12.5% that has to be paid for ZV, and the loan sum for accident insurance is based on your accident risk, so your class, risk class. If we have determined when you register the company that your risk class falls in category which you have to pay 1.25%, you on your own cannot decide and say, you know something, I believe I should only be paying 0.5%, so I will correct it on behalf of SFV that this has to be 0.5%. You can't do that. If it's supposed to be changed, then you have to bring information for us to review to see if it's correct that it has to be changed. And then if it is correct that we need to change it, then we will correct it, and then you will get let you know officially that you have to change, that the accident risk has changed. Companies that are inactive have no employees, but they're still filing nil declaration. If the company is inactive, you don't have to declare anything, because that means you came to the SLV, notify us, we don't have the employees, so for the time being, until we decide, we consider you inactive. Do not give yourself extra work by filling in and this is especially for accountants, because accountants seem to fill in and they tell us that, you know something, the employer is paying me, or the business is paying me to file for him. But you're giving us more work unnecessarily because you don't have employees. So all of these things end up, again, a lot of paperwork unnecessarily for us and for you. The same thing, a company is not registered, but they still filing nil. We even have companies that are not even registered with the SLV, but they file it nil. Why would you do that? Okay? So let's cooperate with us. Don't give us unnecessary work. We have enough work to do already to give you the service that you're entitled to. So don't make our work harder. The employed, oh, this is a good one. Employer thinks bad, so they decide, okay, you know something, as the director, because it's my business, I'm not going to pay myself a salary, but I'm still employed. The definition of being employed is an employee is a person that gives a service and is paid for that service. That means you work, you produce labor, and you're paid for it. So if there's no payment for labor, that means there's no employer-employee relationship. So that means this person would have to be terminated. And maybe it sounds weird that, hey, I'm firing myself, but if you're not getting a salary, you're not supposed to be on the payroll because you're not getting a salary. When you start getting a salary, then you put yourself on the payroll. As everyone knows, as of March, we have a no cash policy. So that means everyone that comes, you pay with your ATM card or your credit card, whichever case it is, or you pay online to the bank, or you go to the bank and pay at the bank. The only exception is for, and what we call, not for businesses, but for what we call in Dutch we say zelfstandig, the independence. So a person that owes AOV as a person, that they get an assessment that they have to pay extra AOV, only in those cases for persons who are 60 plus. So if you're young, if you're not 60 and you have to pay AOV, please walk with your ATM, and our machines are working. Online payments, I understand that online payments is dead. That people when they go make online, we advise you to do online payments if you don't want to pay extra fees. Because when you go to the bank to pay, to pay the SLV, the bank considers that it's a service that they're giving you, so they charge you a minimum fee, I understood, of 50 guilders for you to deposit money on the SLV account. If you don't want to pay that extra fee, then our advice is use online banking, which doesn't incur no extra cost. Okay? I do that every day. Every month, everything I pay online. I don't like to stand in line. So I know you don't like to stand in line either. So go online, do it, and it works. Okay? Because we're up to date. I mean, we trust it. It works for me, so it will work for you too. These are the percentages, which again, we have all information there. You could see it. The maximum wage limit, we see that also, as I stated, it's 5,651 guilders and 36 cents per month. And this year, it was the same amount as last year. Yeah, it hasn't been changed. What is considered wages? Wages, we take in consideration basic salary, vacation allowance, Christmas bonus, child benefit, that's not tax deductible, shift duty premium, standby allowance, dark hours, permanent allowance, wages in kind, probation, commission, tips, dividends, profit sharing, bonuses, payment for contracted work. Again, all this information we have at the service desk. Take in consideration that you have to fill in the ZVOV declaration form correctly, and as a matter of fact, we have since last year we started to introduce the online declaration that is possible on our SZV portal. When you go to www.szv.sx, you can go to the employer section. There's a portal where you can make your declarations online. Yeah, we are trying to meet your needs in order to make it easier for you when dealing with the SLV. And if you don't want to use online, you can always come to our employer's desk to make your payments or inquiries and declarations. And one thing, just to let you know, we haven't finalized it yet, but we are working hard on what we call online mutation, so that we can make it easier that you don't have to fill in all these forms to bring it to us and send them, come stand in line or come to get stamps, whatever. You could do the online mutation yourself, which will make your life and our life easier when it comes, especially those companies that have a lot of mutations. But keep looking out for it, because it will be coming as soon as we reach that so far that we can introduce it. And the intention is that we are hoping that we can reach our target date before the end of the year to introduce it. Especially for contractors, and that's why we have this session, especially for contractors, is what we call the wet keten and sprakelijkheid, the chain of liability ordinance. Okay? Article 1 of the Federal Ordinance, Sickness Insurance and Accident Insurance, the forerunner, what we call the forerunner of the chain of liability, or the Article 1 in the Federal Ordinance, Sickness Insurance and Accident Insurance, where the definition of who is not considered an employee is stated. A personal contracted work unless considered an employer by the plan. So if a person is not known by the SLV as an employer, that person is considered an employee. So a person that is known to SLV as an employer, as a big a company, a business, although it might be an individual, that individual can be considered personal contracted work, and if he or she is assisted by others, are also considered, those persons are considered employees of the main contractor if the company or the person is not known to SFB as an employer. So as we know, you always have a main contractor, and you have subcontractor, and then you have subcontracting, and what happens at the end of the day, nobody knows who working for who and who responsible for the premiums. Now, by the chain of liability, this become a little clearer. Basically, if you as a main contractor don't make sure that whoever you subcontracted to is properly registered with the SFB as an employer, and his or her employees are also registered as employees of that company, we consider those persons who are doing service with you as the employee of the main contractor. Okay? Why did we introduce the chain of liability? Because of the practices in construction sector with regards to subcontracting, to get around the obligation to pay premiums and taxes. You know, everybody always very creative to find ways not to pay taxes. So in order to counteract this, the chain of liability was introduced. It also to determine who is the one liable for payment of premiums and taxes for the different construction projects. It's not a new law, but it's an addition to the, as we call the pay-as-you-earn tax, or the loan belasting rate. Ordinance Article 21A, and this, and you see, this is going back since 2002, so it's not something new, something that exists a while now. The employer-employee relationship. The one who, other than in conducting of a business or in the independent exertion of one's duty, has contracted oneself personally to produce work of material nature for a price. So that means somebody is working for someone else and is being paid for it. It's not for free, you're being paid for it. The person who assists him in the producing of the work. Okay? An employer, all natural or corporate body that employs one or more employees in St. Martin. A foreign subcontractor is considered as an employer if it has a permanent organization or representative in St. Martin or has one or more employees. If the work to be executed is of a longer duration than 30 days, then the foreign subcontractor is considered to have a permanent organization and is considered an employer. Article 21, Pay-as-you-earn tax ordinance, states that contractor that the one who commits themselves towards a principal, a client, outside of an employer-employee relationship to produce a work of material nature for a price. A subcontractor is the one who commits themselves towards a contractor outside of an employer-employee relationship to produce work of material nature and for a price. Premium liability. A contractor has the main liability for the premium contributions that the subcontractor, and if the work is executed partially or fully by one or more subcontractors, each subsequent subcontractor in connection with the task executed by their employees. Okay. Non-liability. If a contractor can, one, make it possible that non-payment of premiums cannot be attributed to him, then the contractor is not liable. That means you have to prove that you are not liable. So it's not just come and say, yeah, I'm not liable. No, you have to prove that you have done everything possible to cover all bases and that you are not responsible for the premiums that have to be paid. If the contractor submits a signed subcontracting agreement with a subcontractor within 1 week of signing said agreement to the SFB, then the contractor will not be held liable. So again, we have to know that you have a subcontracted contract with your subcontractor so that you're covered. Then we know we will contact the subcontractor. Reproachable actions. If the contractor has not done anything reproachable, but the subcontractor has acted in a reproachable manner, the contractor can still be held liable. For example, reproachable actions are the subcontractor does not have or does not maintain a good payroll administration. Not all employees are in the payroll administration. The salaries are higher than in the administration. Non-declaration of premiums and non-payment of premiums while there is liquidity. Not registered at the Chamber of Commerce. or the bid for contract is so low that it's impossible to pay taxes and social premiums. A lot of companies do this. If you know you have to pay taxes and premiums, you cannot bid something that you know you cannot pay the premium because you want to have a profit. You as the contractor also want to put food on your table for your children. So now, if you on the bid just to get a job, you will get in trouble with us. Okay, and not only us, with the tax offices too. So you don't want to get in trouble. Said, and again, some main contractors, big contractors, try to cut their costs by forcing these subcontractors to underbid each other. But at the end of the day, you are the one, as a subcontractor, you are the one who's going to suffer. Because the main contractor, they know, they will notify us on time, hey, I have a subcontract here for Mr. Wilson. So he's subcontractor, so his business. So I did what I had to do. But you know that what Mr. Wilson bid can't pay the premium. So you are being liable, so you are contributing to Mr. Wilson being delinquent. The contractor does not have an administration to establish the wage component sufficiently in the subcontracted sum. The contractor subcontracted even though he fully aware that the subcontractor could not comply with his obligation. So not just notifying us that you have a subcontractor contract, but you have to make sure that everything is fair and that everything is done correctly. Because you can't say, yeah, it's not my fault. It's his business. Of course, once we take a decision to put a fine on you or whatever the case may be, we will, you can always appeal our decisions. We are not God, so you are allowed, you also make mistakes, so you can appeal. The appeal regarding ultimate liability can only be made after the director of the SFB has determined the amount for which the liability exists through a written decision mentioning the grounds on which the liability is founded. The protest and appeal procedure, by virtue of the Federal Ordinance Administrative Jurisprudence, what we call LAR in Dutch, have the following possibilities. If you are in disagreement with the SFV decision, you can submit a written protest to the director of the SFV, Sparrow Road, Phillipsburg, within 6 weeks after the date that this decision has been issued or remitted. In your letter of protest, clear mention must be made of the reasons of your disagreement and also the decision which, according to you, the SLP has to take. Be sure to date your letter and please state on your identification number. In this case, if it's a company, yeah, you put your ID number, but you also put the company crib number and so on with it. Please put on the envelope letter of protest and be sure to sign your letter. Sometimes the letter we can't figure out if it's a protest or just a notification. So if you don't put, you have to specifically mention that it's a protest letter. And this process going to the land committee of the SFV is free of charge. Option 2, you can file a written appeal to the court recorder, the same matter within 6 weeks of getting the decisions, and take in consideration that when you go through the court, there's a court fee that has to be paid. Of course, if you win the case, the SFV will be charged with paying your fees that you have to pay. The employer desk services. We have a lot of my colleagues here who will be able to give you more information if you want. And the employer's desk is, if you don't know us yet, is situated in building 1 at the first level. The services that you get at the service as the employer desk is company registration, company deactivation, employer mutation, employee mutation, loss of wages, FPP declaration, levy, payment arrangements, confirmation reports, yellow cards, accident calls, mutation form, drop box mutations, overview. And just in case, because we know sometimes things are hard, right now we had a situation with Irma, so we know sometimes it's a little difficult for you to pay what you have to pay. Don't hide from us. Come out man up, as they say. Come and say, listen, I have a problem, I want to make a payment arrangement. We are very flexible. We want to work with you. We don't want to close down your business. We want to work with you. But if you go high, and then we have to come run look for you, then we might be a little upset, so we might have to go throw the book at you. So we don't want to do that. So come out and work with us, we will work with you. As I said, we have our website. You go to our website, you have the employers. If you're only interested in information about the employer, you click on it, and it will redirect you to the site where you get all the information you get that is important for you to know. That's www.slv.sx. We also have Facebook, which we try to answer within 48 hours.
2 working days.
2 working days. Okay?